Mrs. A, you have the floor.
Welcome everyone, and thank you so much for taking time out to join us at the LACIAC Live Debates, LLD. It's a great privilege and pleasure to welcome you to the 6th edition of the LACIAC Live Debates. We launched the first edition of the live debates in July 2020. And we have lived up to our objective of maintaining the debates as a continuous series. And we've had 5 previous successful editions to date. The debates focus on developing and emerging issues within the international arbitration community. And it provides a platform for arbitrators and arbitration practitioners to discuss trending and emerging issues. We're grateful to those of you who have been with us from the first edition for your support. If this is your first time, we're very glad to have you and hope that this will not be your last. And we hope you'll have a very enjoyable session. Over 200 people have registered globally. They have registered their interest to attend this event. So I expect it will be lively and a thought-provoking session for everyone. I will stop here before you have to stop me, and I'll hand over to our lovely moderator, Laura Alakija. But before I hand over to Laura, I will do a brief introduction of her. Laura is an arbitrator, accredited mediator, advocate, and certified online mediation expert. Laura's dispute resolution experience covers pre-dispute negotiations, dispute management advice, arbitration, and mediation. She has acted in various capacities in both ad hoc and institutional arbitrations. She's an active member of the arbitration and ADR community, currently serving as member of the ICC Africa Commission and member of the advisory board of the Lagos Court of Arbitration. Young Arbitrators Network, LACIAC. She's a member of the advisory board of the Lagos Court of Arbitration Young Arbitrators Network, known as LACIAC. Laura is passionate about growing arbitration and ADR on the continent, and particularly in Nigeria. She's also one of the organizers of the Lagos Pre-Moot competition. In 2019, she was recognized as one of Nigeria's 40 under 40 rising stars by ESQ Legal Awards. In 2020, Laura Alakija was also recognized as one of Africa's 50 most promising young arbitrators by the Association of Young Arbitrators. And she emerged as one of the successful candidates for the 2020 African Arbitrators Academy in London. She was part of the drafting committee for the widely celebrated Africa Arbitration Academy Protocol on Virtual Hearings 2020. In that same year, 2020, she was appointed the youngest ever managing partner in the history of Primera Africa Legal. Distinguished ladies and gentlemen, I present to you Laura Alakija. Laura, over to you. Thank you. Do your thing.
Thank you so much, Mrs. Akeredolu, SAN, for that kind introduction and for laying the foundation for our conversations this afternoon. I would like to say a quick good morning, good afternoon, or good evening to our participants, depending on where you're joining from. I'm delighted to moderate the 6th LACIAC Live Debates, as Mrs. Akeredolu has mentioned. The previous 5 were extremely successful, and I can guarantee you that this particular debate will be no less engaging and informative. I've no doubt that all the knotty issues around our motion for today will be disambiguated by our debaters as they get ready to battle so that they can clarify the issues and persuade us to adopt the respective points of view. I'll come over to the motion in a bit, but I want to start with a quick introduction. To the left side of my screen, I have Professor Emilia Onyema. She's an independent arbitrator, professor of international commercial law at the SOAS University in London. She's dual qualified to practice law in Nigeria and in England or Wales. She's a fellow of the Chartered Institute of Arbitrators, board member of the Africa Arbitration Association, member of several arbitration courts, including LACIAC. She's convener of the popular and well-attended SOAS Arbitration in Africa Conference Series. She leads the SOAS Arbitration in Africa Biennial Survey Project. Obviously a connoisseur of all things Africa arbitration. She also co-authored the African Promise and founded the Arbitration Fund for African Students, AFAS. You're welcome to the debates, Prof. And then to the left of my screen, I have Mr. Candid Johnson. He's a senior advocate of Nigeria and senior partner at Strachan Partners. He's a fellow of the Chartered Institute of Arbitrators. He's a seasoned arbitrator with specialties in maritime, petroleum, banking, and construction arbitration. He's former president of the Lagos Court of Arbitration and co-author of the circulated and very popular Nigerian text, Commercial Arbitration Law and International Practice in Nigeria. You're welcome to the debates, Leonard Silk. So today our motion, yes, sir. Our motion for today's debate is this House believes that payment of award sums into court must be a condition precedent to challenge of arbitral awards. Professor Onyema will be proposing the motion, and Mr. Candid Johnson will be presenting arguments in opposition. Before we dig into the debates, two quick things. First, I'll start with the House rules, and then we'll take a quick poll before we allow the debaters to argue their positions. So this is a Cambridge-style debate. Debaters will have 15 minutes each to present their arguments in support of or opposing, and then they'll have 5 minutes each for rebuttals. After that, we'll take 15 minutes to do Q&A, the question and answer session. So if you have any questions, please drop them in the question segment and we'll try to address all of them, time permitting. I will keep the time, and if there are any interruptions or overruns, I'll make adjustments and add any lost time to either the speaker or their opponent, depending on the situation. I would like to issue a disclaimer. The opinions expressed by the debaters during this debate may not necessarily represent their actual views on the subject. They would mostly be just adapted for the purposes of this debate. I'm sure they'll enlighten us much later. So before we go into the debates, LACIAC, if you can put up the poll quickly so that participants can vote and we see how the voting goes before we hear the arguments. The question is, do you believe that payment of award sums into court must be a condition precedent to challenge an arbitral award? So if we can quickly answer that. I see the polls are up. I don't know if the voting is done. Please let me know. Are we done? Can the results come up? Excellent. So the results of the poll, for those who believe that payment of award sums into court, we have 54%. And those who believe that payment of award sums into the court should not be a condition precedent, we have 36%. There's 8 people sitting on the fence. So I think that, you know, the crowd is almost evenly split. So you have your work cut out for you. We now look forward to hearing the arguments. So by the powers vested in me by LACIAC, I now invite Professor Onyema to make the arguments in support of the motion. Your time starts now, Ma.
Thank you very much, Laura. Thank you to LACIAC for the invitation. I see that I have 10% of our audience who are undecided. So I already have 54%. So my job now is to try and ensure that I grab as many of those undecided as possible. So to kick off things, what I want to do is just remind you what my job is. So I'm trying to defend the motion that arbitration judgment debtor should pay the amount awarded against them into court before they can challenge the award. And so what I propose to do is just take a step back and ask, what is an award debt? When does the award debt arise? What should happen after the award? What recourse does a losing party have? And why should the court disregard the recourse that is open to the losing party? And then I would conclude. So I know I have 15 minutes, so I'm going to speak a little bit quickly. So what is an award debt? In arbitration, as we all know, where there is monetary compensation or damages that have been awarded to the party who prevailed in the arbitration, and then that award is known, that judge decision award becomes a debt. And so this is really equivalent to what you would get in a first instance court, awarding a certain sum to a party following litigation proceedings. And we know that once you get the judgment, then you follow through with enforcement of that judgment. The key thing to recognize is that the award, that money, that amount becomes a debt that is owed by the debtor to the creditor. A debt that remains unpaid as a question of commercial practice would incur additional compensation because of the loss of the use of the funds over the period that it remains unpaid. And so that is the basis of the proposition that an arbitration award debtor should pay the award debt into court, not to the creditor, but into court before it can challenge the award. We'll come to the reasons why. The next question then is, when does the award debt arise? And the award debt arises following the completion of the arbitral proceedings, which will terminate in that final award. We need to remember that at this stage, the parties would have paid for the administration of the arbitration. They would have paid the arbitrators' costs. They would have paid legal and other costs, so that the prevailing party is not just left out of pocket from the underlying transaction, but even from pursuing the legal redress. So it is obvious that the prevailing party has incurred all of these additional expenses. By prevailing in that arbitration, at least in the first instance, there is the presumption that the party has justified its reason for pursuing the arbitration. So it was not frivolous in the first instance. So what should happen after the award? The parties, by virtue of the arbitration agreement, effectively promise to each other and commit to a collateral contract that they will comply with the final award. Of course, that is subject to the limited grounds for review or challenge or annulment. It therefore follows that following the publication of the final award to the parties, the prevailing party should immediately become entitled to receive that award amount. Any day after that, they are left out of pocket. The losing party's payment obligation arises from the date of that award. That is when it arises, subject, of course, to whatever other terms we have in the award. If such party, therefore, refuses to pay or fails to pay, they are also in breach of the terms of the award. So that's two breaches. They breach the arbitration agreement and the collateral agreement, and then they breach the terms of the award by refusing to pay. And we have arbitration rules that set out the parties' agreement that they will comply with an award that has been made against them. So we move on to the next question. What recourse, therefore, does a losing party have? Does the proposition, does it mean that if you are a losing party, that you don't have any recourse, you don't have any options? That is not what the proposition means. For the losing party, they can challenge the award if there are justifiable grounds under the applicable law. So for now, let's just say the applicable law for them to do so. However, in practice, we know that some losing parties would challenge an award without clear justification. And the purpose is just to continue to frustrate the prevailing party or to postpone the date of payment of the award, or to force the prevailing party into negotiations who may be in a precarious financial situation. And none of these possible reasons is justifiable to deprive the prevailing party, if you like, of the fruit of its labor or spoils of war that it had won. So what is the role of the court? It is for the court or the state really, through its courts, to ensure that that this does not happen. It is not seen to be encouraging such parties to breach their own contractual undertakings. So why should the court disregard the recourse that is open to the losing party? The support of this motion, let me just reiterate, does not amount to the court disregarding the recourse that is open to the losing party under its own laws or any international convention like the New York Convention that it is party to. What the support for the motion does is to strike a balance between the interests of the prevailing party, who has won in the first instance, or at least the first round, and the interest of the losing party, who may have a legitimate interest in overturning the award. In my opinion, the most transparent way for the state via its courts to achieve this balance is to protect the interests and rights of both parties, so the winning or the prevailing and the losing party. And in addition to that, to comply with the state's own obligations under its own national law and international convention undertaking, so its New York Convention undertaking, that it will honor and enforce final awards, arbitral awards. So it would then need to require the losing party to pay the award amount into court. We must notice and acknowledge that the court is a third-party independent fund holder, so that fund, the prevailing party is not using it, but that the fund, it just reassures the prevailing party that the money is there, and then the losing party can pursue its challenge if it wishes. Another option, of course, is for the court to ask the applicant, so the losing party, to provide security for the cost of the challenge application. And when I respond to my opposing party, I have a number of cases that I'm happy to cite. The parties would, the purpose, the advantage of this is that in addition to the state complying with its own law and its own international law obligations, it ensures that the parties can think carefully before they mount award challenges. And this will reduce the number of frivolous challenges that go before courts. And courts, for example, courts in Nigeria, wherein any litigant knows that once you enter the Nigerian court system, you might spend another 5, 10, 15, howsoever many years in that through the appeal structure of the courts. And so that's the final thing I want to say is that having such a rule would be good for the global reputation of the state as a seat, as a safe and good seat that is supportive of arbitration. It will attract more arbitrations as seat. And of course, we know the attendant economic benefits of attracting arbitration, international arbitration to any seat. The final thing I would say is that this particular idea of enforceability is item number 9 on the CIAB centenary principles on a safe seat. So in conclusion, in this manner, so in complying or abiding by the proposition, we achieve equality of treatment of the parties, which, as we all know, is a cardinal requirement of international arbitration. So I will stop there and hand back to Laura.
Thank you so much, Prof, for those arguments, all done in about 11 minutes. So you had extra time if you needed to make any further contributions, but I will now hand over the floor to Mr. Candid Johnson. Quick reminder to the House, if you have any questions, please drop them in the Q&A section so that we'll address them later. Mr. Candid Johnson, I now invite you to present your opposing arguments. Your time starts now.
Thank you very much. Madam Moderator, I beg to oppose the motion respectfully, because I think that the motion is based on 3 fundamentally unsound premises. And I also think that its success would undermine the rule of law by effectively immunizing error and injustice from proper scrutiny and correction. The 3 fundamentally false premises which I think underpin the motion is first, that there is something sacrosanct about the advertised finality of an arbitral award. I think that the process of arbitration itself contemplates that an award may not be final in certain regards because certain errors may be made. And this takes me, if I may just quickly comment on the point made by Professor Onyema, that not paying the award, maybe I didn't get that right, not paying the award would be a breach of the agreement to arbitrate. I think that you contest the award and that you don't pay pursuant to that contest is something that is contemplated by the agreement to arbitrate, because that an arbitrator may be wrong, that errors may be committed, is contemplated by all state laws which recognize and enforce arbitral awards. The second premise that I think is unsound is that speed is more important to law and commerce than justice and legal consistency across the board. The consistency of the law is an important objective of any decision-making process, because decisions are meant to guide commercial and other legal activity. And it's important to have some consistency, which is a responsibility of the state. And the final premise, I think, is that the effective and practical immunity which would be given by this proposition would confer an immunity on an award which is not necessarily the best or the most easily available solution. So that sounds a bit convoluted. There are other solutions to the problem which the law has or can provide, which don't require what I consider to be a drastic proposal. Now, in any organized society, dispute resolution and the proper administration of justice are the responsibilities of the state. Private parties may organize their own private disputes as a means of resolving amongst themselves. As we know, the origin of arbitration is in trades and in associations. But it remains the overarching responsibility of the state to accommodate even private systems of dispute resolution within the context of the rule of law. Now, the rule of law requires that any decision maker who takes a decision must act within the law. This is fundamental. And a function of the appeal procedure or judicial, you know, when I speak about appeal procedure now, I recognize that under Nigerian law, a challenge to an arbitral award is not an appeal. But in reality, as far as legal intent, whether it's a judicial review, whether it's an application to set aside, whether it's called an appeal, as it is called both, in the English 1996 Arbitration Act. It is judicial review, I will call it an appeal. And it is a deliberate device which is essential to a well-organized system of adjudication. And it emphasizes the responsibility of every state to guarantee justice and to promote and regulate commercial relations and to promote consistency in law, which I already said was an important function. And these ideas are consistent with the international approach to arbitration and its enforcement. Now, the context for this proposal is a specific mischief, which Professor Onyema has already referred to some degree. There's a high rate of challenged arbitral awards causing delay. It can often defeat altogether the capacity to recover an award. There is judicial inefficiency and incoherence. Nigeria is a great example. We don't trust the judges that they will be efficient. We don't trust that their philosophy of regulating arbitration is going to be sound and consistent with the highest commercial objective. And we don't have the time to wait for them to exercise their discretion because we don't trust their discretion will be correctly exercised. But on the other hand, the immunity that is granted to an arbitrator who may himself be of spotty ability and who may be prone to a variety of other provocations and influences is that you create a power which is beyond review and which can be exploited also for possibly corrupt motives, also for purposes of intimidating people who do not have the means to. So the fact that you don't have money to pay an arbitration award doesn't mean that you're wrong, and doesn't mean that you cannot exercise the rights provided by law for a very good reason to exploit these remedies to correct error. You know, I think that the appeal system, again, whether you call it judicial review, whether you call it application set aside, the opportunity to complain about a decision given by a deciding body against you to a higher or a different body is as old as the scriptures. Some of you who are familiar with the Bible will remember that Paul appealed unto Caesar. Indeed, the idea of appeal is one of the fundamentals which Justinian wrote about the Roman system, that it was important for good administration that a party who was in a dispute should have the opportunity to appeal to somebody else. So the right to appeal is fundamental. And as one author wrote, an appeal is an institution that exists in all human societies and is designed to limit, if not to avert, the two evils that threaten the administration of justice. The first of those is human malice, and the second is human error. Now, for arbitration to retain its credibility, it has to, as an autonomous party-led process, the courts must strike a balance between, on the one hand, limiting the grounds for review, while on the other hand, ensuring that truly serious errors arising out of the arbitral process can be corrected. Now, there are already procedures for limiting the right of appeal, even in Nigerian law. You have to go through, well, I think that the Nigerian arbitration law, which we had since 1998, is not an optimal example of the type of pathway and the gateway that should be provided to challenging arbitral awards, because relating to misconduct and given almost a carte blanche opportunity to challenge, I think is dangerous. I think better models are those in England, the 1996 English arbitration law, which creates a right of appeal, but subject to leave, which creates opportunities to secure the amount in dispute, subject to the discretion of the courts, and which creates a very steep test for setting aside an award. Now, you know, the reason why the English in creating, and I was reading recently the Saville report on this question as to whether if parties have surrendered to arbitration, they should be restricted from appealing or from challenging an arbitral award. You submitted to arbitration, take it or leave it, which is something the Nigerian courts have said in some of the decisions. In 1996, this groundbreaking report, which preceded the 1996 arbitration law, considered this as an option, but they felt that the report states that protecting the credibility of arbitration requires parties to have confidence that errors that can be made, that are made, will be corrected. You have to recognize human error in any adjudicatory process and give people confidence to adhere to it. Now, one of the things that would be done if you imposed upon every party the inflexible obligation to pay an arbitration award before they could challenge is that you would shut out anybody who couldn't afford to pay. I said already, the fact that you can't afford to pay doesn't mean that the award is correct. So this is a problem. So to maintain the credibility of arbitration, you need to have people be willing to adhere to it. One of the reasons why they adhere to it is because it's relatively fair, because if mistakes are made, there's a system for correcting it. But they also want to know that in a commercial context, across the board, the decisions of arbitral tribunals will be of a very high standard, which is achieved by correction, and that there will be a consistency across the board. It would be dangerous for the future of arbitration because it would be dangerous for the future of commerce if the risk was set in stone and defended by law, so that any crazy arbitrator, and we, even though we are all mostly arbitrators in this room, we must recognize that skill and experience across all those who arbitrate cases is not even, and that there must be a system for regulating. Now, I think that a great model, there are many devices under the law. Professor Nyama referred to security for costs. They talk about payment into court. One that I think is very useful for us to consider is the provision of Section 77 of the English Arbitration Act, which does actually create a direct method for securing monies that may be owed. There are provisions in the general law for securing costs, but even for the award, in certain circumstances where permission is sought to appeal against an arbitration award on certain type of grounds. Thank you very much. At certain type of grounds, it's that section creates an opportunity which is akin to what is proposed by this motion, that the court may secure by order. But even that provision is subject by the decisions of English courts to such a steep test. And this recognizes, consistently, as I said, with arbitration practice across the world, that the confidence that we have in arbitral awards is built in a large extent upon the correctness and the justice of the decisions that will be reached. So I would be careful to create a steep wall against challenging awards whose quality we cannot guarantee and whose effect may be to stifle both opportunities of people who have a genuine case and the attractiveness of arbitration as a service in itself. So to round up, I think that international practice does not support the proposition. Experience of those who have studied arbitration and its effects in commerce does not support that proposition. The proposition is one that attacks a mischief which can be mitigated by a variety of other devices, which rely on the discretion of a court and allow that different circumstances may be reviewed in deciding in a more careful way, a careful way that recognizes that justice is more important than finality and speed, and recognizes that confidence in the system is in the public interest and is something that the states must guarantee. I hope that is a sufficient statement of my side of the argument, and within time as well, I hope.
Yes, very well within time. Thank you very much, Mr. Candid Johnson. That was done in about 12 minutes. So I think that for those who are just joining us, the numbers are going up. We've had very interesting conversations on both sides around whether or not you should pay the award sum into the courts as a condition precedent to challenging arbitral awards. Now, each debater has another 5 minutes to then give rebuttal arguments. If you like, you may provide a summary of what you said before, just for those who are joining the meeting. Professor Emilia, I'll give the floor to you now.
Thank you very much, Madam Moderator. For those of you just joining, what I had set out what an award debt is, what should happen after an award has been made, what recourse is available, and the core issue here, which is how the courts can balance out the interests between the party that has prevailed in the arbitration, who ideally should have immediate access to the award, and the party who lost in the arbitration, and ensuring that the state's obligation to enforce, the state has taken on that obligation by itself, that it would enforce arbitral awards, how the state through its courts can ensure that all the negatives or all the reasons that Leonard Silk, Mr. Candy Johnson had given would actually be mitigated. And so I was smiling when Mr. Candy Johnson, SAN, referred to section 77 of the English Arbitration Act, which he particularly likes. And I would like to read that to you, because it effectively supports my own side of the case generally. So I'm going to read it with relish. So section 77 of the English Arbitration Act 1996 says, the court, looking at whether we should be talking about challenge or appeal, and there is a difference between challenge or appeal. I know that Mr. Candy Johnson had generally sort of interchanged those terms, but the court, the English Arbitration Act says, the court may order that any money payable under the award shall be brought into court or otherwise secured pending the determination of the application or appeal, and may direct that the application or appeal be dismissed if the order is not complied with. I think that second sentence is massively important because it shows how important the first part of that provision is. We don't have an equivalent provision under the model law. And I'm not sure we have under the Arbitration and Conciliation Act in Nigeria. But again, just to pick up on, so to underlie that fact, that even Mr. Candy Johnson's preferred statute, preferred law, gives the courts that power to require that the funds will be paid into court. And in a 2013 decision by the English courts, X versus Y, the court said that the powers of the court to act is discretionary. It is discretionary, and it is unfettered. And so that it is for the court to look at the circumstances. There are other requirements provided in there that the court to guide factors that the court would need to consider. I want to talk about, just pick up 2 points from what to respond to, and that is the issue around the rule of law, and that Mr. Candy Johnson had set out talking about human malice and human error, the law being prepared to intervene on the basis of human malice and human error. And then the second thing I want to pick up on is this whole, what he had talked about that I've already referred to, which is the appeal and challenge. As it relates to human malice and error, in arbitration, we have rules on lack of impartiality and independence of the arbitrator. Remember that it is party autonomy allows the parties to choose their own arbitrator, to choose whoever they want. And we do still remember the addition of Redfern and Hunter, where then Redfern, Martin and Alan had talked about what they consider in choosing an arbitrator who is favorably disposed to their own view. And so we know that in practice, that a lot of lawyers, when they determine who to appoint, what they're also sort of hedging to hope that they appoint somebody who at least will see their own viewpoint. In my opinion, that there's some degree of lack of impartiality in that. And so but arbitration law itself provides for how parties can deal with that. And so the issue around human malice, apart from the fact that we have a challenge, you can challenge the arbitrator, even at the stage of enforcement. We have quite a lot of cases to that effect, where that can be a basis on which that award can be challenged. I would want to say that to remind Mr. Candy Johnson that commercial parties are meant to be sophisticated because they instruct lawyers like yourself, senior lawyers like yourself, to whom they pay lots of money to ensure that they do not end up with people who would be malicious in either with the subject matter or towards them. So I think we need to credit commercial parties with some degree of sophistication in appointing arbitrators. On the question of human error, there is no appeal on the facts or really merits in arbitration. That is the position of the law. And so there are limited grounds to ensure due process that the vast majority of laws allow parties to challenge award on, which means the parties themselves have contracted out of that opportunity and that law. So I would now quickly move. I can see that Madam Moderator is looking at
1 more minute. Yes.
So, should I quickly deal with the last point?
Yes, 1 minute.
Oh, thank you very much. And the last point I would like to pick up is Mr. Candy Johnson had talked about finality of the award and then the contemplation of the point I made around contemplation of the arbitration agreement, which is the fact. And the fact that we look at talking on that rule of law as though speed is more important than consistency of decision making in arbitration. There is no stare decisis in arbitration. It is a private process. There isn't, unless that award enters into the public domain, we're not in a position to know what parties have determined. So I think that's an important point just to bring some degree of clarification. So to just quickly recap and remind our voters that I believe that the House would agree with me that, which is the motion, that arbitration judgment debtor, that the interests, the public interest of ensuring that arbitration judgment debtors pay the amount awarded against them into court before they can challenge the award far outweighs any considerations around challenge or appeal of the award. Thank you.
Thank you very much, Professor Onyema. I will quickly disclose to the House that what I did was allow you your 5 minutes and the extra time you let go during your main presentation. And in the interest of treating both parties fairly, that's what arbitration is about. Mr. Candy Johnson, in your rebuttal, you may wish to summarize what you said before for those who joined us, and you may also wish to take up the extra time you had forfeited in the first rounds. I will now yield the floor to you, sir.
Okay, thank you very much. Well, to summarize, dispute resolution and an arbitration process and the award that it is a product of that system is a human product, which is subject to the frailties of human. I'm sorry that I've had a power cut and all of a sudden the TVs and stuff have come on. So anyway, so it's a product that which the state has an obligation to regulate and which the state does by providing a law for recognizing, for enforcing and making effective the product of a private dispute resolution process. Now, I think that the challenge, of course, in making arbitration viable in any territory is defending or extracting a product which can be recognized as just, notwithstanding that there may be impediments to the speed at which you take delivery. It's interesting that myself and Professor Onyema both agree about the viability and the beauty, I think, of Section 77. But the jurisprudence in the cases, the earlier cases, a case like Peterson Farms and CNM Farming and X and Y, which is 2013, all recognize, and I'm not sure whether in any of those cases, the court ordered that the money be paid into court because the threshold is very high. You would have to satisfy the court that a person who has brought a challenge to an award has brought one that is, I think in the judge in Peterson Farms and CNM Farming described it as flimsy or otherwise lacking in substance or unlikely to succeed. I think use the word shadowy. If a challenge is entirely frivolous, I think that we have to trust the judges to deal with how it should be protected or not. And again, that even the idea of mitigating delay, mitigating the potential that recovery may be completely destroyed by the time that is taken to enforce an award is a matter which we should be able to entrust to the law and to the procedure in the hands of judges and to their discretion. So Nigeria is an example where a case may take, as Professor Ayama said, 10, 5, 15 years to determine. That is the problem. You know, we have to face the problem which is causing us the very mischief which is making arbitration awards ineffective here is not that there's a right to challenge. It's not that you need to punish the person who has lost by saying the only ground upon which you can challenge an award is by paying, which, by the way, the courts, which is effectively a senior dispute resolution process, does not insist upon. Courts will grant stay of execution, courts will grant stay of proceedings, because they recognize that the right to challenge a decision should not be stifled by either your lack of money or your unwillingness to pay. And as long as the process works efficiently, as long as you know that if I go to the court and my challenge is unsustainable, it will dispose of within the next 6 weeks, which is perfectly possible if you come before judges who understand arbitration, who understand that protecting arbitration and creating a one-stop adjudication center, which is what Lord Stein said he was trying to create when he gave the Lesotho decision on the 1996 UK arbitration law, is to make the territory of England safe and profitable for commercial dispute resolution. If we want to do that in Nigeria, it's a responsibility which our courts have to defend. And it's a responsibility of Nigerian courts to make it clear that we will deal with these challenges very swiftly, that we will dispose of with high penalty, we will award interest, we will do a variety of interlocutory opportunities which can be deployed to be sure that swiftly the question that arises is resolved, and that where there is no real question, parties do not have the liberty to waste the court's time and to waste and frustrate the opportunity that victor has obtained by the award. Thank you. And while we're getting, I'm just going to get up and be sure I switch off the TV. So just please go on. I'll hear you.
Excellent. Thank you very much, Mr. Candid Johnson. So the rounds of arguments are completed, but because I have the power to, I would like to keep the debaters on the hot seat a little while longer. So we'll jump straight into the Q&A. Then we'll do our polls after. So I don't know. I think we're still in character while answering those questions. And while Mr. Candid Johnson is taking his seat, I'll ask Professor Oyema the first question. This question is from Kingsley Ibe, and he wants to know, the reasons for your position seem to apply with comparable force to regular court proceedings. Would you support a similar position in respect of court proceedings?
The short answer would be a yes. So do you still want us to be in character, or should we step out of character?
Well,
more fully. But we haven't done the polls.
We haven't done the poll, so maybe stay in character.
Yes, so that I should stay in character.
Yes, please.
That would be a tough one, Laura. Are you sure you don't want us to get this
okay.
sorted,
Okay.
So we can give legitimate answers.
If we had time, I would have asked the opposing party to give me their views before I reach a determination, but please proceed, Prof.
So remaining in character, the answer would be a yes, again, for the same reasons that I gave. There was another question in the Q&A by Momo Kadiri, and talking about, should this question, is it related to particular jurisdictions? And so as Mr. Candid Johnson, SAN himself has conceded that if it comes to the situation before the Nigerian courts, for example, or other courts where we have lots of delays in the system, then that may well help to again help parties to figure out, do I really want to be doing this? But if it is in jurisdictions where decisions are made quickly, then it might not be necessary. And even, I would just want to quickly again mention that Mr. Candy Johnson had mentioned the X versus Y 2013 decision. And there is also another one that was made in 2011, A versus B, which Mr. Candy Johnson is absolutely right. I mean, the threshold is really, the bar is very high. But I've been struggling not to mention P&ID versus Nigeria. Let's remember that Nigeria had to deposit, in the sense that they had to produce bank guarantees for $200 million at some point before they were allowed to appeal that particular decision. And so it's tough these days to say anything on arbitration and not mention P&ID versus Nigeria, but I think that's, I'll stop there.
All right, thank you very much, Prof. Mr. Candy Johnson, I think the next question will work for you. This is from Jesse Nwaewo. And essentially what Jesse says is, it seems that the pitfalls of litigation is creeping into arbitration proceedings, and they want to know what recourse, whether statutory or otherwise, should be taken to ensure that appeals arising from arbitration proceedings are resolved timelessly, as in the case with election petitions.
Well, that's interesting. You know, you provide a solution for what you consider to be a problem. When the 1996 English law was enacted, the English judges gave decisions which indicated very clearly what they intended to see the result to be achieved. I mean, Lord Stein said they intended to create a one-stop adjudication center in the UK. Even before that, under the previous English arbitration laws, the courts, the case of the NEMA was a case which Professor Nyama is obviously familiar with as well, where Lord Diplock gave indications that the rules as to how the court would deal with appeals from arbitral awards and attempts to challenge. So the job of the highest court, you know, when they keep saying Nigerian Supreme Court is a policy court, I don't think they got the point, because the point of a policy court is that it dictates to all the courts beneath it how to deal with issues, and it indicates the importance of those issues to the well-being of the state. It is legitimate for an English House of Lords or Supreme Court to recognize that bringing arbitration money to London is an important imperative for the UK economy. It is also important for a Nigerian judge to recognize that the efficiency of disposal of commercial disputes in Nigeria is fundamental to the economic progress of Nigeria. So this is the point. We consider that elections are very important, so we give them the highest priority. And this is the third time this week I'm being asked about the comparison between the attention to election cases and the attention to commercial cases. Obviously, politics is the big game here, and it's more important than any other thing. It's more important than the criminal law. It's more important than commercial law. It's more important than matrimonial causes. It's more important than trademarks and patents. And that is a fundamental misalignment between the policy of the courts and the progress of the nation. So I think that we need to get an indication, and somebody needs to tell the highest judges that they need to send down policy which guides for the betterment of commercial dispute resolution in our territory.
Excellent. Thank you, sir. I'll allow you to answer one more question just to balance the scales. Then we'll take the poll so that people can relax and have a more fruitful conversation. But there's a question from Hosanna William Adusa, who wants to know that the notion of justice delayed is justice denied. And in your defense, you mentioned that speed is not more important than justice. So how do you balance this?
Well, it's a task for human beings. You know, you talk about writing constitutions which are supposed to endure for 200 years. Human beings can only legislate according to their present understanding. But facts, circumstances, law, imperatives in business, they evolve. And you have to depend on human beings to strike the balance. So you put human beings who will evaluate and who will determine where the balance is to struck, and who will determine how to effect that balance, you give them the highest ability, you give them the highest exposure and training. You choose the right, if you choose the right people, they will make the right decision in the changing circumstances. That I think is the solution. You cannot set the balance in stone. You have to depend on the judgment, and this is why I really believe in judicial discretion. But a discretion is only as good as the person who's exercising it.
Excellent. Thank you very much, sir. And thank you very much, Prof, as well, for this very engaging debates. I feel like I've been in a game of ping pong because I've been moving from one party to the other. LACIAC, if you can quickly put up the survey so that we will see how everybody's minds have been affected by today's conversations, and then we'll come back to whatever Q&A questions we can take. I'm not sure if we're all done voting, but please vote if you haven't, so we can close the polls and go to the results. Okay, voting is over. Waiting for the results now. This is interesting. Our results are up now. I can see that in support of the motion, we have 37%. In opposition of the motion, we have 39%. It's very keenly contested. And then we have an interesting dynamic. Not every time is 24%. I'm having trouble interpreting these results because the first survey we did, Prof appropriated the additional percentage to her side. So how do we split the 24?
We'll have to go to court.
Right. Do we pay any sums into the courts before you challenge this? Well, thank you very much. I think the answers are obvious. There's obviously still a lot of gray area that needs to be addressed. We have over 20 questions, and I noticed that somebody actually raised a procedural question, to ask how do you treat this? Is it the tribunal that then creates this condition precedent before parties go to challenge the award, or is it the court that does it? And maybe these are some of the questions that we have to answer and clarify to be able to decide whether to go one way or the other. But I want to thank you so much both for this very keenly debated contest. I don't know how to declare a winner. I think the jury is still out. Yes, it's a draw. The jury is still out as to whether or not we should be paying award sums into the courts in order to challenge an arbitral award. But I would like us to jump quickly into some of the questions. And after we've had the Q&A, then maybe you can give your final words and disclaimers if you want to. But I see a question here. Okay, I'm trying to follow them. Okay, I see a question here from Hamid Abdul Karim, and he says, for court judgment, it is always to be judgment creditor to ask the debtor to make the payment of the judgment sum into the court. Then the judex will consider whether it is appropriate to do so or not. Why why shouldn't the same approach be sufficient for arbitration? Either one of you can respond.
I think there are a number of questions that
Yes, there are.
track that in the Q&A. And the key thing to remember, we're no longer in character.
Yes.
The key thing to remember is that I think the difficulty with our motion is the idea or the mandatory nature of it, of the proposal, making it almost mandatory that you have to pay. And you know, if we let's just think, I think most people here, almost everybody knows about P&ID versus Nigeria. Let's just think about it. If we had asked when P&ID came to enforce, I think 2017 or something like that, and that amount was this almost 9 billion. If the UK courts or the Nigerian courts or the US courts, because I think they're jumping all over the place, had asked Nigeria to pay in or to produce bank guarantee or something of 9 point whatever billion US dollars, what would that do to our economy? So I think that, you know, we need to put it in context. Maybe if we give that example, we can see that it will be harrowing. That's number one. Number two, remember that it's what stage? And so it's when you file the challenge application. And so think about, let's go back to P&ID. If Nigeria had not started fighting this award and had rolled over and paid and stuck 9 point whatever billion with the courts, the bank charges for that guarantee alone will be something else. And so that's a state. That is an oil producing state, by the way. So can you imagine, one of the questions in the Q&A talked about MSMEs, small businesses. Where do you want them to get the money? And if it was the actions of one of the parties or of the other party that led to them being almost financially bankrupt, what else can they do? So I think that it's a good idea, but it should not be mandatory.
Right.
It should be, you know, similar to what we have under Section 77 of the English Arbitration Act. The important point for me is that the court has the powers, and such powers are unfettered, but there is clear guidance on when you can, you know, when the court can make such an order. It is a very serious order to make, and the second part of 77 makes it really clear the serious nature of such an order.
Right. Thank you so much, Prof. Mr. Candid Johnson, I see a question in the Q&A section where Tabitha Rauri says whether an alternative would be better than having the parties pay the money into courts, for instance, financial guarantees. I laugh a little bit because in Nigeria that has interesting connotations, but I would like to hear your views. Do you think it will still serve justice to have alternatives as to actually putting the money in court?
You know, putting the money into court poses a very crude solution. There's a lot in between that. You know, Mr. Abdul Karim referred to the judgment creditor wanting to have judgment enforced and having presumptively the right to have that money in his pocket. But even in that situation, the discretion of the court on an application for stay of execution is interposed between the judgment creditor and his prize. And the variety of considerations that would be considered by the court include the potential impecuniosity of the judgment debtor, the fact that he has a right to challenge the decision, how serious is that challenge, and whether imposing upon him the obligation to pay would destroy that right. Because if it's important, then you must try and preserve it. And the P&ID case indeed shows just how dangerous and devastating that could be. If you ask Nigeria to produce a guarantee for 9 billion, that would have been the end of the case. And we don't know if there are legitimate grounds to challenge that decision. The force of an award given by private individuals would have overwhelmed the sovereign rights of a country like Nigeria. That is a problem on a wide variety of means, not just from a commercial perspective, but from the perspective of the sovereignty of a nation itself. And that amount of money can take a nation completely out of business. So this is the challenge. Or I've been in cases where the challenge has been corruption of an arbitrator. So an arbitrator makes an award in a claim of $100,000, makes an award of $2.5 million, and says you must pay the money into court because this is, and make no mistake, there are corrupt arbitrators, and they're not all in Nigeria. So I was asked at a meeting once, because I came from Nigeria, whether I had any knowledge of any case of corruption. As it happened, the only one I had was of arbitrators who dealt with the Nigerian arbitration, but they all came from London. So I guess they have these things in every part of the world. I didn't think my interrogator didn't like that particular answer, but then, you know, I like to give difficult answers to simple questions. Anyway, so this is the point. So this again is a matter of discretion, what to do. If somebody is, and even again to go back to 77, if a person is making a challenge in circumstances where he would destroy the capacity of a successful awardee to recover, it is a legitimate consideration. I'm not saying it would be decisive, but someone must exercise a judgment on what to do.
Right. Thank you very much, Mr. Johnson. For a moment, I thought the internet froze. I see another comment. This is from Yasin Gwemri. I hope I got that right. Who says, wouldn't a middle solution be to block the amount in a bank account, essentially freeze that award sum in the prevailing, in the challenging part, in the prevailing parties' accounts until the courts determine. And I wonder, Professor Onyema, do you think that that is a viable alternative to paying the?
I would resist that sort of alternative because, you know, you can move money just like that, and then the money is gone, the money is gone. I think that payment into court, really, it's not, in most cases, it's not like you basically carry that much money and go and dump in the account of the court. It's more like giving guarantee that when the court asks you to produce it, you produce, and it's a guarantee given by a third independent party, which is a bank. I think that's important. And that is a court. It's not the arbitrator. There's another question there that talked about the arbitrator who should make this decision. It can't be the arbitrator. It has to be the court because the court has enforcement powers. And so the court can say to the bank, release this P&ID is now 11.1 billion with interest, release the 11.1 billion. The bank has given an undertaking that the bank would make that payment. Right. So why would that not be a much better and a more transparent and objective mechanism than carrying that money and putting it in one of the parties' accounts?
Right.
Certainly not my account or Mr. Johnson's account.
A joint account, maybe.
You know, that's an interesting perspective because I see that Harrison Ogalagu says, you know, that both ancestral model law and the New York Convention on Resisting Recognition of Enforcement of Foreign Arbitral Awards state that state parties or states should not impose more onerous conditions during enforcement proceedings. And so he's wondering whether the requirement to put the sum in an alternative account or even to give the bank guarantee. You know, I had alluded to the interesting circumstances around bank guarantees. There are situations where a bank would only give a guarantee if you have that money in their system, which comes to almost the same thing if you ask me. You know, so wouldn't it amount to imposing a more onerous condition if we actually go ahead and tell the judgment debtor to pay the money into the courts or put it in or freeze it in the banks?
That would be the contrary. It's the other way around. Remember, it's the judgment debtor that
Yes.
is being asked. So it's actually supportive of enforcement. And so it's not the creditor, it's the judgment debtor that needs to produce that security really to the courts. And about the court, about banks demanding that you have that money in your account, that's your problem. That is your problem. You know, that is a separate issue because that's the cost to you of having to produce that guarantee.
Thank you very much.
I don't know if Mr. Candy Johnson.
Andy Johnson, if you have any thoughts
Well,
to add.
I think that a bank guarantee is more important, is easier than cash. From personal experience, I would resist to the highest court paying any cash into any courts within easy reach of me, where I sit, and I won't bother to say what country I'm in, but this just by the way. So I think that's something, and I should say that there are circumstances, in my opinion, where it would be appropriate to make a judgment debtor pay the money into court or give security for the payment. There must be some respect for the finality of a decision. It may be wrong. So there again, it's how you balance and how you mitigate. But I think that there would be circumstances where someone is trying to hide assets or someone is trying to dissipate. But then on the other side, someone says, you know, here's the entire working capital of my company. If you take this money, the business shuts down. What do you do? And it's a way in the past where big corporations have destroyed smaller corporations. I mean, the famous case of Prudential and Newman, the English case, which took 14 or 15 years of trial. The Newman Industries was destroyed thereafter. I was at a meeting recently where I was explaining how intellectual property works and protection in Nigeria, and some young guy in jeans and a t-shirt from Silicon Valley says that he appreciates the lawyer wearing a suit, by the way, and a tie, what he thinks about intellectual property protection. But he says, but if Apple interferes with your intellectual property, and there's very little you can do because they'll put 300 lawyers on your case. So Apple gets an order against you, and your justice is completely obliterated by the fact that you don't have the power. You don't have the power. Sometimes the court needs to balance, hold the balance between the weak and the strong. That's also a legitimate function of justice in any territory.
Can I quickly say that just at the back, off the back of what you've said, listening to the news yesterday about the decision coming out of the US courts against Fox News, it made for interesting reading. And so, but again, those are I think the issues around, and the uncertainties, not just the issues, but the uncertainties around litigation as well. The day before trial starts and you're coughing out a few hundreds of millions of dollars. And then you sort of, maybe the shareholders should be asking them, if you don't want to put your 92-year-old on the stand, why didn't you settle?
Well, in this case, the shareholders are already asking those questions because the directors have a responsibility to the shareholders and to the promotion of the business. Yes.
You know, so which means this discussion goes. I think that there is a wider question around the reasons why and how you run your dispute resolution mechanism and why you do that. And I think there's a very strong issue around jurisdiction, where you are and what are the peculiarities of that particular jurisdiction. And so there are too many unknowns in this wonderful basket that we've made sound like it's a straightforward black or white situation. It isn't. There are various shades across that spectrum. I think that's the disclaimer, speaking for myself and Mr. Candy Johnson, who was my boss a few decades back. And
now she's my boss. But anyway, the solution, I think, to many of these problems, efficiency and effectiveness in justice administration solves many problems. And efficiency and effectiveness also applies to those who you put in these positions. So many of these things where we're saying, well, what would happen? How would it, you know, this is the solution. And I think that we can identify the mischief, but we can't isolate arbitration and think. Many people who practice arbitration in Nigeria have started with the assumption that by practicing arbitration, they have saved themselves from the rigors and the dangers of and the weaknesses of the judicial system. But the arbitration is as effective as the system in which it's going to be operated and enforced. This is why the English courts signal that if you come here, we will defend your arbitration, because we need the money. Nigeria needs the money. We have to get a better game.
I agree 100%. Thank you very much, Mr. Candy Johnson. Thank you, Professor Emilia. Ladies and gentlemen, you heard it here. There's no hard and fast rule. The question is not as clear-cut as it seems. The mandatory nature of our motion for today makes it a little bit interesting. I think the takeaway is that this needs to be treated on a case-by-case basis. And of course, the final point that the efficiency of the justice system also determines, you know, how best these issues can be addressed. I think, you know, to add my 2 cents from a strategy perspective, I would also be reluctant to let my clients pay that sort of money into court. If nothing else, the fact that you've lost half the battle by paying the award sum into some place is like swimming against the tide to try and recover that money from the court system. But I'm not the judge in this matter, so I will leave it with what the debaters have told us and thank them very much for their time. I would, at this point, like to invite Dr. Ajibade to give us the thanks. Ladies and gentlemen, I think we've addressed all the questions or all the clusters of questions, just so you know. Dr. Ajibade, if you are on the call, please give us.
Thank you very much, Laura. On behalf of LACIAC, I thank, and on behalf of all of us who have listened to this very, very stimulating debate, I thank our debaters and Ms. Alakija, who has moderated it so ably in bringing these issues into such clear relief. This is the 6th of our debates, and I must say, I think without a shadow of a doubt, this has been the one that has elicited the greatest level of participation from the audience. So clearly a very topical topic, pardon the pun. Hopefully you've enjoyed it as much as we have, and we look forward to your participation in future editions of the debate. Thank you very much, everybody. Have a great day, what's left of it.
Thank you.
Thank you very much.